SCR 2446. This is the People versus Brian Sarnti.
Your Honor, Jacob Matthews for the People. Good morning.
Morning.
Good morning, Your Honor. Levi Price, 48938, on behalf of Mr. Sarnti, who appears on WebEx from the jail. I'm appearing on WebEx as well, Your Honor.
All right, Mr. Sarnti, can you see and hear us?
Yeah.
All right. Case comes on for hearing on a complaint for revocation of probation. Mr. Price is counsel entering his appearance on this case. Mr. Price, what's the status, please?
Your Honor, we're asking first to address bond. I have spoken with Mr. Matthews about that. Your Honor, the new case does not allege a violation of probation. Mr. Sarnti has not violated his probation. We are asking for a significant reduction in bond. I know Mr. Matthews is looking at the case, but if the court even reads the affidavit in the new case, it does not state a violation. And so I'm very concerned that he was arrested on that affidavit. He has not violated the law and he has not violated his probation, and we're asking for a significant reduction, Your Honor.
Okay, and so are the people prepared to address bond?
We are, Your Honor. The People are being confined. The named victim is present, wishes to address the court.
Okay, and so Mr. Price, you're by WebEx. Mr. Sarnti's by WebEx. He has a right to participate in a bond hearing in person. Does he wish to proceed by WebEx?
We do. He does.
All right, Mr. Sarnti, let me check in with you. I just indicated you have a right to be present in person for a bond hearing, but we can proceed with you by WebEx with consent. Do you give your consent to proceed by WebEx?
Absolutely. Thank you, Your Honor. Yes.
All right, you have a right also to have your attorney physically present with you whenever you appear remotely, but we can proceed with Mr. Price by WebEx separately with consent as well. Do you give your consent?
Absolutely. He's fine by that means, yes.
Is anyone forcing you to appear by WebEx against your will?
Not at all.
All right, let's have bond argument from the Mr. Price.
Your Honor, in this case, the basis for the complaint of probation is a new law violation. I have reviewed that affidavit. It does not state a violation. Mr. Sarnti did not violate his probation. He did not violate the protection order. He was in the area, but nowhere near 100 yards as required by law. He did not send any notifications, and his comments to the officers are protected by the First Amendment. And so I'm deeply troubled that he was arrested on this, and we would ask for a significant reduction as Mr. Sarnti has not violated probation in any way.
All right, from the people.
Yes, Your Honor. And I would ask that Ms. Clark be able to address the court.
All right.
Good morning, Your Honor.
Good morning.
Good to see you again.
I don't know about that, but good morning.
All right. Less than 1 month ago, on May 18th, Mr. Sarnti entered into a plea agreement. At that time, I asked you to consider jail time in place of probation because, quote, I have major concerns now, knowing that he is continuing this behavior, that if he receives no jail time and is let off GPS, he's going to come straight for me. It took 8 days. Only 8 days before Mr. Sarnti came to the mall where I work, a place where he has been trespassed by mall management, Lakewood PD, and this court. Another condition of probation was mental health treatment. He has already stated that he refuses to take medication, meaning he's refusing treatment. Mr. Sarnti has already been gloating that he won and that he didn't do anything wrong. He has zero remorse or accountability for his actions. I would actually ask that you increase the bail amount. Mr. Sarnti has proven time and again that he will not comply with any orders given by this court. I would also ask, just as I did the last time that I was here before you, he thinks that he is above the law and untouchable, and I beg you to show him he is not. Thank you, Your Honor.
All right, thank you, Ms. Block.
And to clarify the record, he was not in the mall, Your Honor. That's not the case.
All right, Mr. President, I'll give you a chance to speak again after I hear from the people.
Thank you.
And Your Honor, just for the record, the new case that's being discussed is 26 CR 1077. Mr. Sarnti was arrested on that case on June 1st, or excuse me, on June 2nd. The warrant went active on that case on May 29th. In that case, probable cause was found by Magistrate Kendall, and at bond hearing on that case, co-counsel for Mr. Price made a record objecting to a finding of probable cause, and Judge Pepper sustained a finding of probable cause on that case. In that case, Judge Pepper set bond in the amount of $750,000 cash only, which was significantly higher than requested by either the people or defense. But Judge Pepper indicated his own significant concerns. I'm asking the court to maintain bond as set. I believe that we are evaluating our case, and while Mr. Price and I have discussed this matter, and he disagrees with the finding of probable cause, and that any charges were brought, and what the people are doing our due diligence in our evaluation of this matter. As was stated, this case occurred weeks after Mr. Sarnti was sentenced before this court. So I'd ask that the court maintain bond as set.
All right, Mr. Price, go ahead.
Yes, Your Honor, the three allegations in the affidavit are statements made to the officer that are in no way, shape, or form a violation of any law or the probation. That he was in the area of the mall, not in the mall, and not within 100 yards of her workplace, which is where he was prohibited from. Judge Pepper now increased that area to the entire mall and the mall complex, but that wasn't the rule on the day he was there. The day he was there, the rule was 1,000 or 100 yards, and he was never inside of that. And the final allegation, which I do believe is the only basis for Magistrate Kendall finding the probable cause, is that there was a notification that the victim received. Your Honor, that's not a notification Mr. Sarnti sent. That was a notification she had set up on her own phone to tell her when he was in a larger area than the prohibited area. So at this point, I think you heard from the DA that they're evaluating that case, and that's because there is no case there. And he was on probation for 8 days. He's had no opportunity to comply with mental health treatment, and he did not violate any terms. And so we're asking for a significant reduction. He can't just be arrested because someone's upset that he's a half a mile away when the order is not to come within 100 yards.
Okay, so first of all, the 26 CR 1077 case is not before me. And as far as I can tell from looking at the record in this case, there was the initial probable cause determination, and there's a PH schedule in that case for June 30th at 8:30 to determine the precise question as to whether the case should be bound over to this court. So I'm not in a position. Is Mr. Price still there?
Yes.
Okay, your video cut out, so I can't see you. I'm not in a position to assess the
Yes.
facts.
Yeah, sorry.
Of that. I'm not in a position to assess the facts of that case, Mr. Price. That's going to be something for another judge to address at this point. It sounds like, at least based on what I'm hearing from the attorneys, that there might be some merit to that argument, Mr. Price, but I'm not making that decision on my case. On my case, there is a complaint for violation of probation that was alleged by the probation department based on a new law violation. The new law violation is allegedly against the same victim as in the prior case. My experience with this case has been that there have been violations of bond conditions or alleged violations of bond conditions, which resulted in warrants issuing, which were quickly paid. Mr. Sarnti did not remain in custody. And those bonds that were initially set were set high based on this court's common practice because of the community safety and victim safety concerns about Mr. Sarnti. And those were easily posted. That's what resulted in this case, at least with respect to the current complaint, to the court posting a higher bond than usual in order to assure the community safety concerns. That case needs to be resolved, the other case, and it may be resolved as you've indicated, but at this point I have sufficient community safety concerns such that the court is going to deny the bond modification request. So how would you like to proceed?
Your Honor, we would like to set a hearing on for the violation of probation within 14 days.
All right, so that's going to take you to, we had a first appearance on this case on, I'm looking at the wrong case now, hold on. June 4th. So let's do this. We can do this Thursday morning at 8:30.
Your Honor, I'm not available at 8:30 Thursday morning. I'm in a vehicular homicide motions hearing in front of this court.
Thursday?
Excuse me, my apologies. That hearing got moved, but I can be here at 9, but I cannot be here at 8 o'clock on
All right,
Thursday.
we'll do 9 o'clock. Mr. President?
Okay,
I am not available Thursday. I was wondering if it was at all possible maybe to do that Wednesday, because I'm in trial in Fremont County Thursday.
Thanks.
I could do 9:30 on Wednesday.
That works just fine for the defense, 9:30 this Wednesday.
Mr. Matthews?
Your Honor, I'm triple set with other matters, but I will make it work.
I appreciate that, Mr. Matthews.
Okay, 9:30 a.m. Wednesday, June 17th, 2026, for hearing on the complaint. We will see you all then. Mr. Price, anything else?
Nothing else today.
Anything else from people?
No.
All right, Mr. Sarnti is remanded. We'll see you back on Wednesday. Thank you.
Thank
you so much, Your Honor. Appreciate it. Thank you, Levi.
Thank you. All right, court is going to call Ms. Galleo Perez's case. This is case number 25 CR 1414, People versus Kimberly Galleo Perez.
Robert Bennett for the people.
Hannah Algich for Ms. Calvino Paredes, who appears in person.
All right, good morning. Just a moment. All right, this case comes on for pretrial conference today. I do have plea paperwork that's been filed into the case. There's a petition under plea of guilty with a proposed disposition where Ms. Galleo Perez would be entering a plea of guilty to count 2 assault in the 3rd degree, class 1 misdemeanor, with no objection to 12 months of probation with anger counseling and mental health evaluation and treatment. And in exchange for the plea, count 1 and 2, 1 and 3 would be dismissed. Is that the proposed disposition?
Yes, sir.
Ms. Galleo Perez, do you wish to enter into this plea today? Do you want to enter into this plea today?
Yes, Your Honor.
Okay, get closer to that microphone. I'm going to go through an advisement with you to make sure you're making a knowing, intelligent, and voluntary decision this morning, that you're thinking clearly. If at any time you have any questions for your attorney, please let me know and I'll give you a chance to talk to her privately, okay?
Okay.
All right. You need to speak up though, because we're recording what you're saying, and so we need to be sure to hear you, okay?
Okay.
All right. Are you under the influence this morning of any drugs, alcohol, or medication that would affect your ability to understand this hearing?
No, Your Honor.
Are you under the influence of any physical, mental, or emotional condition that would affect your ability to understand this hearing?
No, Your Honor.
The petition includes a signature line on page 5. There's a signature that appears above the defendant's signature line dated earlier today. Did you sign the petition under plea of guilty?
Yes, I did.
Did you review it with your attorney before you signed it?
Yes, I did.
Did she answer all your questions about it before you signed it?
Yes.
Did anyone force you to sign the petition against your will?
No, Your Honor.
Paragraph 4 is on the first page. It indicates you're not currently serving and that you've never served in the U.S. Armed Forces. Is that statement correct?
That's correct.
Paragraph 6 of the petition is on the next page. That paragraph lists the rights that you have in this case. Did you review those rights with your attorney?
Yes, Your Honor.
Did you understand them?
Yes.
You understand that by entering a plea today, you're giving up those rights.
Yes.
Means you're giving up your right to a speedy and public jury trial in this case. You understand that?
Yes, Your Honor.
You're also giving up your right to have the district attorney prove the charges against you and each element of those charges against you beyond a reasonable doubt. Do you understand that?
Yes.
Paragraph 7 indicates that you want to enter a plea of guilty to the original count 2, which is assault in the third degree, a class 1 misdemeanor. Is that correct?
That's correct.
Paragraph 9 is on the bottom of page 2. That paragraph sets out the elements to the offense you'd be pleading guilty to. Did you review those elements with your attorney?
Yes, I do.
Did you understand them?
Yes.
As indicated in the petition, if the court accepts your plea in this case, you could be sentenced to a fine of up to $1,000 or up to 364 days imprisonment in the county jail, or both fine and imprisonment. You understand that?
Yes, Your Honor.
The petition indicates the district attorney has no objection to 12 months of probation in this case with anger management counseling and mental health evaluation and treatment. Is that your understanding, Ms. Galleo Perez?
Yes, Your Honor.
Is that the people's concession here?
Yes, Your Honor.
You understand it's entirely up to the court as to whether or not to grant probation in the first place.
Yes, Your Honor.
You understand that the court does grant probation. The court can still impose a period of incarceration of up to 60 days of straight jail or the maximum jail sentence in the form of work release as a condition of probation. You understand that?
Yes.
The court accepts your plea. I'll listen to sentencing argument from your attorney and from the district attorney, but the sentencing decision is entirely up to me. You understand that? Has anyone put any pressure on you to enter a plea today?
No.
And have you been satisfied with the assistance of your attorney?
Yes.
Ms. Halachis, did you sign the certificate of counsel?
Yes, Your Honor.
Let's have the factual basis.
Yes, Your Honor. On May 1st of 2025, around 7:30 p.m., Ms. Galleo Perez entered a Little Caesars pizza restaurant on North Sheridan in Jefferson County. Argument erupted between her and an employee. She struck the employee repeatedly in the face, breaking her glasses and causing lacerations to the victim's face.
Is that what happened?
Yes.
With respect to count 2, assault in the third degree, a class 1 misdemeanor, Ms. Galleo Perez, how do you plead?
Guilty.
Court will find that Ms. Galleo Perez has made a knowing, intelligent, voluntary plea in this matter with an understanding of the nature of the charges, her rights, and possible penalties, that she has been represented by effective and competent counsel, and that there's a factual basis for the plea. Based on those findings, the court will accept her plea at this time and dismiss counts 1 and 3 on the people's motion. How do you wish to proceed, Ms. Halachich?
Your Honor, resting for immediate sentencing.
Any objection?
No objection.
All right, go ahead for the people, Mr. Van Ness.
Yes, Your Honor. And the people are in compliance with the Victims' Rights Act. We contacted the victim. She did not wish to provide input on this case or the plea. Ms. Galleo Perez has fairly extensive history, but most of it is from when she was still a juvenile. As an adult, she has, I believe, one conviction in one case for vehicular looting and POW out of Denver, 19 CR 616, where she completed a Department of Corrections sentence. In this case, Your Honor, it was, I think, appropriately charged as a felony, but at the end of the day here, they were arguing over breadsticks. My impression, being more generous to Ms. Galleo Perez, is that, things were tight. She was stressed about money, and so I did not appreciate being told that she needed to pay for more things that she thought were included. All that to say, her reaction was obviously inappropriate. She certainly did assault the victim and cause some lacerations. I believe the victim needed 3 stitches. So I think she's actually lucky this wasn't a more serious assault here. But I can understand that she may have been stressed and that this kind of arose from a misunderstanding. So I am not objecting to a probationary sentence here.
All right, thank you. Ms. Halachich?
Your Honor, so in terms of the robbery allegation here, there's a lot of context that's important. We have surveillance footage from that day. And, when this case originally came in the affidavit, it says that the theft here was of breadsticks and soda. The theft ultimately was of sauce, allegedly. So just to break things down here, Ms. Galleo had gone into the Little Caesars that day. She's on camera, literally giving cash to the store employee. She steps out at one point to get exact change, comes back in, hands over that exact change, and this is all visible on camera. In front of the employee's till, there were a variety of sauces, like small sauce packets. Ms. Galleo, again, on camera in front of the employee, grabs one of those sauce packets. I think very reasonably assumed that those were free packets. that would come with the breadstick order. She then was on camera waiting around. After about, I think, 10 minutes, went up to the employee, was asking about the status of the breadsticks. There's no audio in this footage, but this is information that I've picked up from going over the discovery and then also from Ms. Calvillo kind of filling in some of the gaps here. At that point, when she went up to the employee told her, well, you stole that sauce. I'm not going to give you anything at this point. Ms. Calvillo, what she took issue with was being accused of stealing something because she did not believe that she had stolen anything. She thought that this was included in her order. And so she was offended by that, which I think is fair. I think, her taking that sauce was something that was reasonable to do. So the breadsticks were being kept from her. She then went behind the counter to grab the breadsticks herself. And at that point, the employee actually grabbed her first. And then Ms. Calvillo, in response to that, did strike her. Ms. Calvillo then actually started to walk away. The employee grabbed her again and ended up pushing her against the wall. At that time, Ms. Calvillo was actually pregnant with the child that she had earlier this year. That was a high-risk pregnancy. She had a really high miscarriage risk. And so she was very upset by that. And I think, reacted in part. But I think everything that led up to this person being struck in the face is really important context here. This was not a random assault that came out of nowhere. I think there was a lot of buildup to this. And I think, Ms. Calvillo always really took issue with the robbery here because she did not mean to rob anything that day. Ultimately, those breadsticks she had paid for. Perhaps she shouldn't have gone behind the counter and she let her temper get the best of her. But she wasn't trying to steal anything from the business that day. Important for the court to know is that she has an open DNN case right now with one of her children. She has 3 children. She's been doing well in that case, is involved in a lot of different treatment as part of that. She's actually already doing anger management groups as part of that, has been doing individual therapy, is actually doing medicated assisted treatment as well. She continues to report to the court there and is working hard to get full custody of her middle child. She also has an older child named Chris. Chris is autistic and requires a high level of care. And so Ms. Calvillo is usually caring for Chris, her oldest child, Eviana, her middle child, with whom she has the open DNN case, and then her baby, Prince Thomas, who was born this February. So she has 3 kids that she's taking care of. She's very actively involved in the DNN case. She's been doing well there from everything I understand. She already is doing a ton of treatment. And ultimately, this case did happen a year ago. I think now she's been getting a lot of the treatment that would allow her to maybe approach tense situations differently and reevaluate them. Ms. Calvillo is also a young person. She just turned 26. I think, she wants to be there for her children. She wants to be responsible. I think she's very much on the path to doing that. So all that to say, I wanted the court to have a little bit of background here to kind of understand the outcome in this case. And we are asking that the court go along with the recommendation, give her an opportunity on probation.
All right. Before I turn to Ms. Galleo Perez, any restitution being requested?
No, Your Honor.
All right, Ms. Galleo Perez, anything you want to add before I make my decision?
I just would like to apologize to the courts because I think I was just caught up in the moment. I was pregnant. And I feel like it could have been handled differently. I really tried to, talk to the manager. I asked for a manager. Her response was like, I am the manager. And she said she wasn't going to give me my food that I had already paid for. So I feel like it could have been handled differently. So I know what I did wrong. So I just would like to apologize for that.
Okay, Ms. Galleo Perez, I think probation makes sense under the circumstances of the offense here. So given the plea in this case is to an M1, we'll do 12 months of probation, standard terms and conditions as agreed, mental health evaluation and treatment, and anger counseling. No restitution is due and owing. We're going to give you an order to go down to the probation department. They're on the 2nd floor of this building. When you get out of the elevators, go left, go all the way down the hall and check in with them before you leave the courthouse. If you don't, they're going to file a complaint and ask me to issue a warrant. Let them know about your DNA. Well, when you do your intake, let them know about the DNA case and everything you're doing there so that they don't duplicate supervision. But they're going to have to start coordinating, and you're going to have to continue to work with our probation department, but they're probably going to look at what you're doing in that DNN case in terms of supervision and treatment. So I am ordering anger management, which might already be an aspect of what you're doing, but you'll have to tell them about it, okay?
Okay.
All right, bond is discharged in this case. Anything else on this matter, Ms. Alchich?
No, thank you.
Mr. Venice?
No, Your Honor, thank you.
All right, Ms. Galleo Perez, just wait for that order, then go down to the second floor before you leave the area, okay?
Thank you.
All right, good luck.
All right, now are we ready on the Anderson case?
Yes, Your Honor. Thank you.
Fortunately, call number 29 on the docket in 2025 CR 3345, People of the State of Colorado versus Andrew Anderson. If council could please enter their appearances.
Your Honor, Sean Moynihan for the people. And Anthony Vigil Martinez with the Public Defender's Office on behalf of Mr. Anderson, who appears in person at council table.
All right, thank you. We are set today for a restitution hearing. I had inquired earlier the parties as to whether or not we were proceeding to hearing today, and the indication was that we were not. So, Mr. Moynihan, do you want to make an additional record at this time?
Yes, Your Honor. When this was set for restitution hearing, near the end of May, I asked staff to email the listed victim because he is cooperative. He was going to appear the last time, but we called him off because it became a status. But he's been in communication with us, so he's not reluctant. Clearly, he's not. He doesn't have to be served because he made this request and he said he'd be here. But we did email that to him late, I think at the end of May or right at the beginning of this month. I was gone for the past 2 weeks out of the country, so not on email. When I got back yesterday, I did see he responded, I think June 3rd, if I could just, June 3rd, Your Honor, saying that he was sorry he would be out of the country that day, which is today, June 15th. He stated, I won't be back till the end of the month. So I informed counsel this morning, Your Honor. That email was sent also to our legal secretary, but she did not, think to forward it to the defense. And as I said, I couldn't see email till yesterday. So he's out of the country, according to his representations. I don't know where, but that's what he stated. And he says end of the month. I don't have a date given by this victim, Mr. Albark, A-L-B-A-R-Q. So I can't proceed. I would need him. He's a necessary witness. I would ask to continue this. I don't know if the court sets it in reasonable future. I don't think the court needs to find good cause to extend it beyond, I think, the 91-day deadline.
I believe it's 63 days from the time of the filing of the motion, if I recall correctly.
Yeah, I think the court wrote in its order dated May 13th, I think it said by July 9th.
That's correct.
So I don't know if we can fit something in. He just said the end of the month. That's our request.
Mr. Villar Martinez?
Thank you, Your Honor. So understanding that this has been a case that's in a weird posture, defense has been attempting to serve a subpoena duces decum on Mr. Albark, and that this whole thing has become somewhat messy. We're objecting the continuance. I'm also asking the court to dismiss at this time the entirety of the restitution complaint, given noncompliance with 603(2)A, requiring the government to present all compiled restitution documentation to the court within 63 days of conviction. The purpose of that, Your Honor, is for the court to be able to determine whether or not the government and the alleged victim are entitled to a hearing on the merits of the request. And understanding that with some reservation, I did address the merits of that request and I'm not sure I would call it documentation, but the inventory that the defense was provided in discovery. I think even if that were provided to the court, it would be insufficient based on what the court and the officers of the court know about this case. And I understand that submitting that inventory would put Mr. Moynihan in a difficult position here. Because as the court and counsel can tell just from the motion here, the allegation of 100 cases of beer, a sound system, a garage door, multiple computers being able to fit into a station wagon with a storage capacity of just over 27 cubic feet would be a fantastical allegation, to be sure. And I understand Mr. Moynihan's reservation here. I know that his office has made several attempts to get actual documentation that Mr. Albark even owned items totaling that amount. But given that there is no documentation of that, nothing upon which the court can base a finding that a hearing is entitled in this matter, we would be requesting that the court dismiss that, or in the alternative, in consult with Mr. Anderson and in a thorough review of the surveillance videos provided in discovery, Mr. Anderson is willing to pay an amount of $50 in restitution, given the various amounts of what I would characterize as refuse that can be seen loaded into that station wagon on surveillance.
Mr. Moynihan, a response to Mr. Villar-Martinez's argument that the documentation is insufficient that has been provided thus far.
It's true that we did ask for any solid documentation of these lost items and whatnot. And we did get, again, just sort of a list of items. And I'm aware of counsel, Mr. Villar-Martinez's problems with the discovery insofar as how it may or may not support this request.
Well, and I guess my question, and I'll pose this to both counsels, the way I read 2A, it says the court shall base its order for restitution upon information presented to the court by the prosecuting attorney who shall compile such information through victim impact statements or other means to determine the amount of restitution and identities of the victim. It says the prosecution attorney shall present this information to the court prior to the order of conviction or within 63 days if it was not available prior to such conviction. And then says the court may extend this date if it finds there are extenuating circumstances. I don't see that there's a specific requirement as to the documentation. And in part, the restitution hearing itself is not solely limited to whether or not the actions were the approximate cause of the restitution, but can be the amount and determination of the totality of the restitution. That's for the purposes of the hearing. So I'm trying to see where there's a requirement that there needs to be some kind of additional documentation provided to the court prior to holding that hearing.
I think it doesn't have to, there's no requirement that there be sort of hard copy documentation. It'd be much better, it's more convincing, but.
Well, and I can say if none of that information is provided at the hearing, then the court may not find that there is evidentiary grounds to order restitution based on that lack of information. But I'm trying to see where in the statute it requires specific documents detailing the restitution amounts and items that are required.
I think a court can do a restitution hearing with just oral testimony. That's not ideal. I think I've done them though in the past where the person just says, I don't have receipts. I didn't keep my receipts for my stolen stereo. This is what my memory is of what it cost, and it's gone. Theoretically, that's sufficient. The court can consider that the weight of that evidence, but I don't think there's some necessary hurdle to get over.
So, Mr. Villa Martinez, where am I missing something in the statute that says that there is specific information that has to be provided prior to the actual restitution hearing?
So what I'm relying on, Your Honor, is the portion of subsection 2A that requires the prosecuting attorney to present the information to the court either prior to the order of conviction or within 91 days.
63, though,
I'm
correct?
sorry, it was previously 91, it is now 63. Your Honor, at the very least, I think that would have required this inventory to have been filed with the court, understanding that, or at least my understanding is of the attempts to reach out to Mr. Albark is that he does not have any documentation despite owning an LLC of any of this merchandise or equipment. Understanding that at a hearing might go towards weight, there is still a structural requirement that documentation compiled relating to this request be filed with the court within those 63 days. The motion requesting restitution was filed, I believe, on the 60th day after conviction. That was May 7th. Conviction entered on March 9th. We're now 99 days outside of that conviction. And at this time, Your Honor, I do not believe that the court has documentation such that the court can even find that a hearing here is entitled.
Well, and that's why I'm trying to understand what do you think the documentation is necessary? Because when I read the statute, it says, who shall compile such information through victim impact statements or other means to determine the amount of restitution and the identities of the victims. Here, the prosecution has made a request for an amount of restitution that was filed on May 7th of 2026, requesting a amount of $98,825 to be payable to the White Diamond Event Center. So there's been a motion filed which identifies the amount and the identity of the victim to be paid. I don't know what is more required based just on the language of the statute. It doesn't indicate that there's specific types of information that needs to be provided to the court. It just indicates other means to determine. So I guess my question is, what is the specific information that you believe is required by 18-1.3603?
So, Your Honor, I would submit that on the one hand, that there is no further documentation. I think that in my conversations with Mr. Moynihan, it's very clear that his office has reached out for any verifiable documentation of ownership of any of these items, and that they've been met with just simply an inventory, a typed up list of items. So I would submit at this juncture.
So are you indicating that that in its face is insufficient for a restitution hearing?
I believe that it is, Your Honor. And certainly if the court is inclined to reset a hearing at this point, we intend to present evidence to the court to the effect that there is a physical impossibility that even a fraction of this could have.
And certainly, I think that that's an argument that can be made in regards to whether or not the court should order a restitution. But I think that is better left for a hearing to determine both any kind of credibility standard. And where I'm saying this is, so let's say, you know, an individual is walking down the street and they have cash in their pocket, and someone robs them, and they indicate as part of restitution, they would like the cash that was robbed from them, but they have no ATM receipts, nothing like that. They just had let's say $200 in their pocket. There's not going to be any documentation for that. So then it would become, is there credible evidence that's presented at a hearing that the person actually had $200 and that was actually taken during the incident, I don't think they're precluded from having a hearing because there's not documentation in support of that. And so that's where I'm wondering, is there a requirement that I'm missing within the statute that requires some type of documentation, or is the allegation that there was property lost and it is identifiable to a specific individual and the amount essentially of property that was lost sufficient to then trigger the requirements of a hearing? Then whether or not that request is credible and whether that request can be linked by proximate cause to the actions of the individual, that is something that can be determined at hearing. And so that's where I guess I'm asking, I'm not seeing anything in the statute that indicates there's specific requirements that need to be filed with the court prior to triggering the hearing.
And so, Your Honor, I agree. This is a matter of statutory interpretation. The way the defense construes that is that at the very least, even in the hypothetical that the court is posing, that a victim impact statement would be required there, and that those are the kinds of things that are filed along with a request, so that the court can make preliminary determinations about whether or not a hearing is appropriate in a case. Because it is after the filing of those documents that the court sets or does not set a hearing. If the court is inclined to move forward with that, I think we are at a juncture where the defense would ask to proceed to hearing today. We would stipulate to the admission of the inventory provided to the prosecution today for the purposes of that, simply because, one, given the lengthy now history of Mr. Albark avoiding service on SDTs, I don't have any confidence that he will ultimately appear for a hearing. And based on what we know from the prosecution's efforts to get a hold of him and get additional documentation, learning that there is none that exists, I don't think that Mr. Albark can actually provide anything informative to the court beyond that inventory. So we would ask to proceed today, and we would stipulate to the admission of that inventory for that purpose.
And then, so you are objecting to the continuance request by the people?
Yes.
The court at this time, based on representations from Mr. Moynihan and contact with the victim, will find that the request for the continuance in this matter is reasonable. There's been an indication that the named victim in this case is unavailable through the end of the month of June, but would be available after that. That being said, the court has one day available for hearing, and that is July 6th. So the court can set this for July 6th at 1:30 p.m. At that time, we will go to hearing. If the people do not have a witness available, then the court is going to dismiss the request for restitution, as the people have represented today, that this is essential witness for them to meet their burden. I would note that the deadline for the court to order restitution, absent of finding of good cause, is July 9th. And I would indicate that at this time, the court's not going to find unavailability of a witness as good cause for a continued delay.
Thank you, Your Honor.
We would ask for that, the July 6th if possible.
1:30 p.m.?
Yes.
Yes, thank you.
Then the court will reset this matter to July 6th, 1:30 p.m. For a restitution hearing. And as I indicated, if the people are unable to proceed at that date, then the court would take further action.
And I want the court and defense to know, I understand counsel's problems with this large request. So therefore, I do want to interview and question Mr. Albark to get a better idea of how he compiled this in view of the discovery and why he thinks the defendant was indeed the person who took this. I just want Mr. Viel-Martinez to know that I will sort of hopefully get a time to ask this victim about that.
I think based on the objection filed by Mr. Viel-Martinez, that sounds like a good idea.
Yeah.
So
Agreed. Thank you.
If something will change in the meantime and the people do not wish to proceed forward, they can certainly advise the court via written motion.
Thank you.
Thank you, Your Honor.
All right, thank you. Then, Mr. Anderson, we'll see you back here on July 6th at 1:30 PM, unless you hear otherwise from Mr. Vigil Martinez, but that will be the next court date, sir. All right. Thank you, sir. And have a good rest of your day, Mr. Anderson, and you as well, Mr. Vigil Martinez. And good afternoon, Mr. Braddock.
Good afternoon, Your Honor. Here for Mr. Nahar.
The court is going to call number 20 in the docket, 2024 CR 1266, People of the State of Colorado versus Matthew Nahar. If counsel could please enter their appearances.
Your Honor, Sean Moynihan appearing for Elizabeth Walsh and the people.
Your Honor, Chris Braddock, appearance counsel for Mr. Nahar. Mr. Nahar is not present.
The court had continued this matter back on June 5th in regards to Mr. Nahar, who did not appear on that date. There were representations that Mr. Nahar was currently in the hospital. The court had set this matter over for both documentation to be provided as to Mr. Nahar's hospitalization and for further updates. Mr. Braddock, what's the status of Mr. Nahar at this point?
Your Honor, I don't know. I spoke to him through text yesterday. He said he would be here. I have had communications with his girlfriends and with Mr. Nahar previously, where he had been admitted into Denver Health, but I don't have any documentation.
He's not provided you any additional documentation then?
Initially, he provided me a picture of his wristbands showing admittance, but that was back on the first time when we started this process. The representation he gave me and his girlfriend gave me for the last court appearance was that he had been admitted, but I don't have any documentation of that.
All right. Mr. Moynihan, the people asking the court to issue a warrant.
If I could just have a moment, Ms. Walsh left notes. She just has a history of this issue with the hospital. I would ask for a bench warrant. It looks like he told counsel he'd be here and he just has not shown up.
Court had also indicated on the last court date that it would need documentation in regards to Mr. Nahar's hospitalization in relation to the previous stay before the court executed a warrant. Given that nothing has been forthcoming in regards to that documentation and that Mr. Nahar is not currently present here today, the court is going to find that he has failed to appear. His case was scheduled to begin this morning at 8:30 a.m. Current time is 2:10 p.m. And Mr. Nahar has not appeared, so the court will find that he has failed to appear in this matter. Court will revoke bond at this time. Actually, he's not on bond, is he?
I believe this is a summons.
This is a summons. So the court will indicate that it is going to issue a bench warrant in relation to the failure to appear. Court will issue that bench warrant in the amount of $10,000 cash surety property. Is there anything else we need to address in regards to Mr. Nahar's matter from the people?
No, thank you.
Anything else from the defense?
No, Your Honor, thank you.
All right. Then thank you, and thank you for getting over here this afternoon, Mr. Braddock. Hope 2300 treated you well.
No.
Well, have a good rest of your day, hopefully, then.
Thank you.
Thank you. Have a good afternoon.
You too, Mr. Moynihan.
Shefsky. Mr. Shefsky, come on up to the podium if you could take your hat off in the courtroom. Good afternoon, sir. This is 26M2280. Did you get this orange advisement sheet when you came in?
Sir, I did.
Were you able to read it and understand it?
Yes.
Do you want me to go over those rights any further with you today?
What's that?
Do you want me to go over those rights any further with you? Mr. Shefsky, you are here Because you have been charged with a class 1 misdemeanor called assault in the 3rd degree. A class 1 misdemeanor is punishable by up to 364 days in the county jail and up to a $1,000 fine or both imprisonment and fine. And Mr. Shefsky, since you are out of custody, you no longer automatically qualify for court-appointed counsel. But sir, if you are indigent, we would appoint an attorney to represent you for free. The only way I know if you are indigent is if you fill out the application for the public defender's office. We gave you a copy of that application when you checked in. You could take that over to their office. Unfortunately, they're not in the building today, but their office is just across the parking lot. There's a map on that application. Take it over there, fill it out, turn it in, and if you qualify, they will have an attorney for you at your next court date. You could also hire your own attorney to come represent you in this case. And might I ask, are the people VRA compliant to discuss an offer with Mr. Shefsky today?
We are, Your Honor.
So, Mr. Shefsky, if you wanted to talk to the prosecutor without an attorney present today, it sounds like they would be willing to talk to you. You do not have to talk to them. If you do talk to them and you decide that you still want to get an attorney, I will give you time to do that. So what would you like to do, sir? Do you want to go?
I'll just talk to him. That's fine.
All right, then why don't you have a seat? We're going to pass the matter. They'll come talk to you as soon as they're available, and then we'll call the case back up. All right, let's recall the Shefsky matter. This is 2280,
And Michael Meineke for the people, Your Honor.
All right, Mr. Shefsky, we passed this matter so you could talk to the prosecutor.
Yep.
And I have now been handed a plea agreement that says that you're going to plead guilty to attempted 3rd-degree assault. That's a class 2 misdemeanor. In exchange for that plea, all the other charges will be dismissed. And the people are recommending I sentence you to 1 year of supervised probation. Mr. Shefsky, is that your understanding what we're doing here?
Yes, sir.
Mr. Shefsky, are you aware that the possible penalties the court could impose for this class 2 misdemeanor are up to 120 days in the county jail, up to a $750 fine, or both imprisonment and fine?
Yes, sir.
And sir, do you understand the court's not going to be bound by any promises that anybody has made to you about what sentence I'm going to impose here today?
Sure.
Mr. Shefsky, as I look over this plea agreement, I see that it's got your initials on many of the paragraphs and your signature here on the last page.
Yep.
Did you sign this document?
Yes, sir, I did.
Is that because you're able to read it and understand it?
Yes, sir.
And Mr. Shefsky, did the prosecutor go over the elements of attempted 3rd-degree assault with you?
He did.
Sir, those elements are what the prosecutors would have to prove beyond a reasonable doubt in order for you to be convicted of this offense at a trial. Do you understand that by pleading guilty here today, you are waiving the right to make the prosecutors prove this charge beyond a reasonable doubt?
Yes, sir.
The people are not seeking any restitution here, so I'm not going to talk to you about restitution. But on the first page of this plea agreement, sir, there's an advisement of rights that you have and rights that you give up when you plead guilty. They include the right to be represented by an attorney, the right to plead not guilty to these charges and request a trial to the court or to a jury, the right to appeal if you are convicted at that trial, and the right to consult with an attorney about any collateral consequences of this plea before you plead guilty. Collateral consequences could include immigration consequences like deportation. Mr. Shefsky, knowing that you are waiving all of the rights listed on this document, do you still want to plead guilty here today?
Yes, sir.
Has anybody forced you or threatened you to get you to plead guilty?
No, sir.
Has anybody made you any promises to get you to plead guilty that we haven't talked about here in court? Are you under the influence of any drugs, alcohol, or medications right now that interfere with your ability to understand what we are doing here today?
No, sir.
For the people, is there a factual basis on this case?
Yes, Your Honor, this ultimately amounts to a situation involving road rage. The victim in this case was a USPS driver. There was an argument that unfolded between the two parties here in this case. Mr. Shefsky pushed that driver, caused him to fall over and hit his head. That driver talked to me here in court today and ultimately said that he is not really seeking any sort of jail punitive sanction here, just wants a guilty plea for his day in court here.
All right, Mr. Shefsky, how do you plead to the charge of attempted assault in the 3rd degree? Guilty or not guilty?
Guilty.
I will accept your guilty plea as knowingly, intelligently, and voluntarily made. Mr. Shefsky, is there anything that you would like me to consider before I impose a sentence in this case?
It was just a one-off thing and won't happen again. I learned my lesson.
I hope not, sir. You're too old to be fighting with a UPS driver.
It was stupid. Stupid mistake.
All right, I will follow the recommendation here. I'm going to sentence you to 1 year of supervised probation.
Gotcha.
I will dismiss all the other charges. Mr. Shefsky, the next step is you're going to check in with our probation department up on the 3rd floor of the courthouse. Do you live here in Adams County?
Yeah,
Okay.
right on the edge. Yeah.
Yeah, you're on the Adams side.
Close to Jefferson, but yeah.
Okay. All right.
I can make the drive, it's fine.
Well, yeah, I mean, why I'm asking is where you're going to be supervised by probation. If you're closer to Jefferson County, it may be easier for you, but talk to your probation officer about it.
Okay.
If they file a motion, I'll sign it for you to transfer the probation. Check in with our probation department up on the third floor of the courthouse today. They're going to give you a date for your first appointment and a time to come back, and then stop by traffic windows 1 and 2 on your way out of the courthouse to make arrangements to pay any fees, fines, and costs.
Okay.
Any questions?
No, sir.
All right, good luck.
Okay, thanks, sir. Have a good day.
Oh, we need you to come up. Also, we gave you a fingerprint order. I do need you to take care of that fingerprint order.
Okay.
Come on up.
I've got Miss Rose present. Please come forward. Good morning. People are represented by Mr. Martinez. Miss Rose, I think, Miss Lopez, are you on the case now? Did you enter? No.
We entered on the probation cases because complaints were actually filed.
Okay.
Yeah.
I just want to make sure. Okay, so Miss Rose is present with her attorney, Miss Lopez. We do have an amended complaint that was filed on the 8th. Do you waive further advisement of the amended complaint?
I do. I sent her copies.
Okay, very good. And then, let's see. I understand there may be a new case next door.
No, I had that dismissed.
Oh, okay.
So, and that was going to be what I.
Okay.
The protection order that was filed into 25 CR 12.
Mm-hmm.
And I think I understand why, maybe the reasoning why, but we did not actually list the Frisco Police Department as the protected party.
Okay.
And it was for that reason that it was dismissed.
Okay.
Um,
But there was, I thought, a 100-foot thing and,
But I guess still because there was no protected party referenced. But I guess my request was going to be, because I don't think that there should be a no contact order for the whole police department in case she has her own, in case there's an emergency, she needs to contact the police.
sure.
So I was hoping to just check box 3. which
Okay.
is- Or box 1, which is the no harassing, molesting, intimidating. And that be the only box that's checked. That'd be the only condition. And then we list Frisco PD as the protected party.
And that I think makes sense. 100 yards away, the way that Frisco, where they are situated is within 100 yards of the sidewalk. So that
Right.
means that she can't even walk down the street. If they're listed there, just in general, the Frisco Police Department with the no 100 feet. I know that previously Judge Jones had done an advisement on another case that I also got dismissed with similar issues. She had indicated to Ms. Rose that, it's not illegal to walk down the street. You can walk down the street, just don't be going onto the property. And so I think there's just significant issues, and this has come up in Eagle as well, when the entire police department is written down as a no contact, because that's a community safety
Right.
issue.
Absolutely.
I understand the don't harass, molest, intimidate, being on there, but in terms of not being able to be within 100 yards or like any distance requirement or contact in general makes it very difficult. In this case that had just come up on Friday, she was walking on the other side of the street. A police officer was making a stop, a traffic stop with somebody else. And she was alleged to have looked in his direction and smiled and then kept walking. And then they went and busted down her door in her where her residence. And so that was uncalled for behavior to begin with. But if walking down the street and looking in the direction of a police officer is going to get her arrested every time, that's just harassment, in my opinion, because she did not say anything. She did not wave to them even. She didn't do anything in any manner but walk down the street and keep walking, and happen to turn in the direction of a police who's pulling somebody over and giving them a ticket, which is a natural reaction for us all. So, and then they took extraordinary steps instead of, even if they thought they were going to, that they had probable cause based on a protection order they believed was properly in place, did not go get a warrant or anything like that. They just went straight to her house, and when she refused to let them in, they just busted in after her and essentially tackled her onto a bed and arrested her.
How soon after the event?
Like an hour.
Okay.
Yeah. I was already back home.
Why they didn't probably
watching
get a
YouTube
warrant.
on my phone.
Right.
And yeah.
Okay. Well,
I was only on
I will just
that.
say, and I know your attorney wants you to be mindful of your right to be silent, Ms. Rose. I don't mean to be interrupting you, but, you know, I think we've addressed this restraining order before, and the court has entered it the way that it was requested, which I think was 100 feet away from the department. But I see the sense in changing it to the way that Mr. Martinez has requested. So I can't really make any further comment, but it sounds like the dismissal was appropriate based on those facts and circumstances. And I want to get it right because I don't want it to be used as a weapon. I don't want to have Ms. Rose continuing to get arrested on cases that are dismissed. I don't want the department, you know, to feel like they're not being protected. I am well aware of the original cases, all of the facts and circumstances. I understand, Ms. Rose, your position in a crisis mode, reaching out for help and not being treated very fairly. I also understand, though, the slashing of the tires and some of the comments and threats that were made against the department. So, you know, but I think Mr. Martinez is acting reasonably. You have a right to have, you know, if you have an emergency, I'm, you know, to have emergency services. They have a right to have some protection, and we don't need to have you keep being arrested and then cases dismissed. So if you would repeat that, Mr. Martinez, for Marcy, I will. It sounds like you've done VRA. It sounds like this is the request. The defense is not objecting. So to keep, no harass, molest, intimidate, retaliate against,
So
name them as a protected party and take away the 100 feet.
yes, so right now we have boxes 1, 3, and 6 checked.
Okay.
6 has the 100 yards thing as the court is referencing. So I would ask to not check boxes 3 or 6, to just check box 1, and to explicitly list Frisco Police Department as the protected party within the protection order.
Okay.
And
So-
and I do think
so
that
we're-
that would serve the purpose
So
of it.
do you understand that, Ms. Rose?
Yes, that's
Okay.
perfectly reasonable.
Okay, thank you. I'm sorry.
And I was just saying, I do think that that will ultimately serve the purpose that everybody is looking for here, so that there are not any unnecessary arrests or cases developed, and that the Frisco Police Department does feel sufficiently protected. The other thing I would note, Your Honor, is there do appear to be concerns from Mr. Burney about how Ms. Rose is doing on probation, and that she has not reported in Buena Vista since transferring it to Chaffey County.
Okay. So the original complaint was filed in March, and then the amended complaint. And I'm not sure of the differences between the original and the amended. Is it more failures to report or testing? Or Mr. Birdie, can you just, without me having to pull them up and read them, I'm sorry.
It's just further non-reporting to probation.
Okay.
And further non-reporting to drug testing.
Okay, that's what I
As well
figured.
as the fact that it continued, we still do not have any evaluations completed.
Okay. Okay, thank you. I did read, so Ms. Rose, did you move to Buena Vista?
Yes, Your Honor. So after
When?
spending the whole winter at my dad's house and dealing with everything, you know, it's been stated that Frisco and living with my dad is not the best place for me. And by the end of the winter, I was just so over it. And we had that big heat wave back in March. So I was like, all right, it's camping weather again. I'm moving down to Buena Vista. And just to get away. And the last time I had court, Ms. Lopez stated that, you know, all parties pretty much agree that that was the best thing for me to do to get away from the Frisco Police Department. And yes, I'm perfectly aware of my Fifth Amendment rights. Don't care. I speak the truth. I'm not here to manipulate my words into sounding as good as I possibly can. I speak the truth, which is something the police department can't do. I'm happier and healthier than I've ever been, or not ever, but in years. I got back into yoga down there. I am living out of a tent, but I like my lifestyle. It's not ideal. There's things about it that I don't like, but I'm perfectly comfortable living the way that I live. I'm happy down there. The only reason I was planning on just doing this virtually again, like I have the last couple of court dates, the only reason I even came up to Summit County in the first place was because I had several different memorials to go to this weekend. I had a former boss on Saturday and a really good friend of mine that I've known since 6th grade that we've been through everything together yesterday. And that's the only reason I'm even in the county right now. I've only been up here for a few days, and the first thing I do, I'm just simply skateboarding around town. And I was on the opposite side of Main Street from Town Hall, but then the officer had somebody pulled over on that side of the street on the same block as Town Hall, which is the only reason I crossed over the street to be on the Town Hall side, because I didn't want to skate right past the officer. And I just looked back to see if he noticed me on the sidewalk. That's why I looked back, and we made eye contact, and then I just kept skating, went home, was minding my own business. He showed up at the door. I just cracked the door open a little bit. What's this about? I'm not supposed to talk to you. You're under arrest. I'm like, what for? And then he screams at me angrily, you're under arrest. That's when I reached back behind me to grab my phone to record the whole incident. And that's when him and Officer Hornick, who started all of this, who, as soon as I saw him, I was just like, I don't want to see him right now. And that's when they barged in and tackled me onto the bed. My dad just happened to not be home at the time. He was out getting groceries, and I broke my sunglasses, which is like the last thing I'm worried about, but it's like, and I kept repeating to them, I was like, I am allowed to walk down the sidewalk. Like, that has been stated explicitly. That exact situation came up the last time we met. And this is the third time in the last year, not just the second. There was the two, restraining order incidents that got dropped. But there was also last summer, the officer that arrested me on Friday was harassing me. I was just sitting in the park in Frisco, in the historic park under the gazebo, and he drives by. And then a second later, I see him walking around the corner. And, did you flag me down? No. Oh, I thought you flagged me down and wanted something. No. And then he just approached me and wouldn't leave me alone. And I started getting aggravated, and he kept telling me to stop yelling at him. And I kept saying, I will stop yelling at you if you just walk away and leave me alone. I have nothing, I have no business with you. Just walk away. There's no reason for you to be here. And he just kept talking and wouldn't go away. And then he issued me a ticket for yelling in public, which was immediately dropped. I didn't even see a judge on that one. So this is the third incident where I've had a charge brought upon me from them that's been dropped because it was absolute nonsense. I have no desire to be back in Frisco. I just want all of this to go away. And regarding the probation, I have been doing better on my own. Ruby and I were talking back when I was still in jail last year that probation, I was seriously considering just doing extra time just to do time served and get it over with so I didn't have to do probation. Because we both agree, as people who have been very heavily involved in the mental health field for our entire lives, that probation does not help people. It sets them up for failure. Because what it says is that they don't trust me to do the right thing as a 39-year-old adult without my hand being held. I do not need a mental health evaluation. I have seen so many therapists, many of them very incompetent. You can clearly see that, I'm not, some, barely functioning hobo on the streets. I've spent my entire adult life in treatment, therapy, counseling, recovery centers, studying psychology, spirituality, sociology, psychology, all of that stuff. And I am the only one who truly knows what's best for me. I am a Satanist, and our main tenet of Satanism is posted right up there on the wall. It's believe in yourself, not an authority figure, not some mythical being. Believe in yourself. And the second main tenet is bodily autonomy. No human being has any authority over another human being. And like, I just want to get away from all this because the last time I met with Mr. Burney, he literally forgot about me. I came in for my appointment like usual at the scheduled time, called on the phone. Yeah, I'm here. Okay, I'll be right up there. I waited for 45 minutes in the lobby after our scheduled appointment time before I decided to give him another call. Oh, I forgot about you. And then the last time he emailed me, he gave me the wrong date for this court date, which I had to confirm with Miss Lopez. I was like, I thought it was the 15th. He told me the 18th. And it just like the last 4 drug tests that I took before I left Summit County this spring were all completely negative, including marijuana, which it takes a while for marijuana to get out of your system. It's the only thing I've tested positive for in this whole ordeal. I'm still clean and sober. I'm doing great. I don't have a phone number, which is awesome because when I go back to my campsite, I can't just sit there and doom scroll all day. I have to be in town to get on the internet. And I love that. A few weeks ago, I even specifically went up to a couple police officers in Buena Vista who were sitting having coffee outside a coffee shop, just taking their break, and thanked them for being nice and reasonable because I've had a few brief dealings with them in the past. And every time they were perfectly just very friendly, very understanding, not harassing me. And I went up there and thanked them and told them everything about the stuff going on in Frisco and why I'm down in BV. And they know I'm homeless. They see me walking around with my big backpack on all the time. They don't care. They just want to make sure I'm safe. And my intent is never to harm anybody. Which is why I took it out on the tires when I did. Because I felt like after trying to contact the police department multiple times and getting nowhere, that a message needed to be sent because qualified immunity allows corrupt police officers to basically do whatever they want and get away with it. I mean, we've seen officers get away with blatant murder in this country because of qualified immunity. And it's the only reason I haven't sued them yet. But after this incident on Friday, I very much plan on suing the police department. So, I personally feel like I have served my time. I did 4.5 months in jail last year between the 2 stints. The first 35 days I was in last winter, I was confined to the holding cell where they don't turn the lights off ever. And that's like a low-level form of torture. And then when I was in the women's pod, I'm isolated to myself for no reason other than it's state law. And it's one of those laws that I understand in like a bigger prison or whatever. It's meant to protect people. But in my case, it did nothing but harm me. All of this started because I called for help when I was feeling suicidal and I wanted to not kill myself. So I reached out and was manipulated and tricked into handcuffs and abducted from my home against my will by a corrupt officer who has absolutely no capabilities to empathize with anybody. He made it clear that day, this is Officer Hornick from the Frisco Police Department. He made it clear that day that he does not care about other human beings. While I'm sitting in the hospital screaming, pleading for them to just put a gun to my head to end it all because I'm in so much pain, he's sitting there, just a smug, satisfied look of contempt on his face, just staring at me, just waiting for me to lash out at him so that he would have a real reason to arrest me. He clearly did not care. When I was strapped handcuffed spread eagle to the hospital bed in the emergency room in front of about a dozen people, the rooms are all glass right there. You can see and hear right into the lobby of the emergency room. I was then stripped naked, taken one limb out at a time of the handcuffs by police officers, not the doctor, stripped naked so that I could put a hospital gown on which I didn't want to do because I didn't find it necessary. They were like, well, you might have something on you. Well, I got patted down when I came into the building. While they're doing this, there's about a half a dozen officers sitting there smirking, giggling to themselves, laughing about it. Clearly, they did not care that one of their own citizens was going through the absolute worst day of her life. And up until that point, I had never legitimately thought about killing myself or tried. Since this happened, I have tried twice. Once when I was brought into jail and was coming down off of a bunch of different substances and freaking out. And then the other time last summer in Salida, when after I read the article in the Summit Daily about the SMART team getting awards, and they detailed in the article that the SMART team exists specifically to prevent exactly what happened to me from happening. And that threw me into a massive depression. And so I tried to overdose on pills. That didn't work. And a couple days later, when I was withdrawing from that and super angry, is when I decided to call the Frisco Police Department and just one last attempt to try and get any sort of apology or acknowledgement from them that they maybe didn't handle things the right way. I've never wanted anything from them other than that. And when they wouldn't even give me that, that's when I lost it. And it was an empty threat. I had no intention of actually harming anybody. I was in Salida with no car. Like, there was no imminent threat. And I understand the severity of death threats, but like, I'm autistic. I have a hard time not having really, really intense emotions. And because of having to live in a society that doesn't generally accept that sort of behavior, I've had to mask and bottle things up my whole life. So when stuff like this happens, I tend to exaggerate my reaction. And I know that Frisco is just trying to do anything they can in the hopes that that will happen again and they'll have a real reason to throw me back in jail. They have been targeting and harassing me this whole time. And it's just, I still have nightmares about the whole situation 2 years later. And like, I firmly believe that I have served my time. Like, I don't need the government to hold my hand to do the right thing. I'm an anarcho-communist. I believe that we all should help one another and do the right thing without having anybody to tell us. Because forced morality is not morality. And legality does not equate to morality. The Holocaust was legal under German law at the time. So, like, just because I'm, breaking the law doesn't mean I'm doing anything wrong. Like on Friday, I was just skateboarding down the street. And I firmly believe that if I'm not actually harming anybody or anything, there's no point in having a law about it. If there's no harm done, it doesn't matter. That is my personal belief. And I'm just like, I tried to get my probation transferred down to Salida, but then I realized like, I didn't have the money to get to Salida. I'm not going to hitchhike. I'm a trans woman. I would much rather not hitchhike if I can avoid it. And I don't have the money to pay for drug tests. Thankfully, Gary was providing vouchers when I was up here, so I didn't have to pay for them. But they're $30 a piece. Plus, if I were to take the Mustang down to Salida, that's another $12 round trip. That's $42 for a random drug test that I don't have. I was happy and content with my life down in Buena Vista. I wasn't harming anybody. I wasn't getting into trouble. I was staying sober.
Okay, Ms. Rose.
So, yeah.
I'm sorry, I don't mean to cut you off, but we're getting a
Fine.
little behind. You've had a lot to say, and I always find you very articulate, and I think it's your story is compelling. First of all, I'm sorry for the loss of your friends.
Thank you.
There's a lot that you said that I sort of adamantly disagree with. Our probation officer has about an 80% success rate. So I don't think we're setting people up to fail. Does it work for everybody in every case? No. Is it working in your case? Maybe not. I understand, your rights to believe in what you want to believe in. And I've never heard the term anarcho-communist or belief in yourself. I mean, I think that's a good thing. But I disagree with you that, there are laws that you must follow. You're absolutely right. The Holocaust was basically, there's a lot have been written about that, about how Hitler rose to power and how judges were faced with either following the law that they disagreed with or death. So that was some challenging times, but we are a far cry from that most of the time.
Not really anymore.
Well, you and I are going
As a trans woman, I can disagree with you on
you
that.
are going to disagree with me, and I'm not in every aspect of society. I totally agree with you on that. But and I think that you do have a lot of insight, and you've studied a lot, and you've researched a lot, and you have unique experiences that have given you a lot of insight into mental health. And I'm sorry for your suicide attempts. I'm glad they were unsuccessful. You've done a lot of work, but I still think that I'll be honest with you, I think you have some more work to do.
We always do.
Always, right? I mean, I think you have these intense emotions, you have anger, you have so many things with regard to the Frisco Police Department, and it goes both ways. It absolutely goes. You have their number and they have your number. And it's like, but recently you have been trying to abide and been, in the right, I would say, more than they have been in the wrong. So that's, and I don't know what to do with that. There's so much personal animosity between you and that department. It's really unfortunate. And I think that, I'm glad to know you're doing very well in BV, and it sounds like you've, maybe found your village, found your tribe, found your community, which I know you were looking for even in Denver not too long ago. And I hope that that is the case. But we need to bring it back to kind of where we're at here, which is, you did plead guilty to 2 pretty serious crimes. You're put on probation. There's allegations you're not following probation. Legally, I have to move the case forward, which requires an either admission or denial, and then some sort of resentence. And I don't want to put you back in jail. I'm still traumatized from hearing your experience about that. That was a horrible experience for you. So I don't, so that's what I'm charged with doing, is how do we move this case forward? And so I'll ask Ms. Lopez, and I don't know if you and Mr. Martinez have had any discussions about it, or what the next steps are.
We haven't.
We have not.
And I think that, I don't know, Mr. Martinez, how long you've been on Miss Rose's cases, but maybe I think that was great to hear kind of her version of events. So maybe a discussion is appropriate for you two to have a discussion, obviously with Miss Rose input, and try to be creative and figure out a path forward.
Okay, and I guess, so I'm happy to talk after this. I can't speak to everything that Ms. Rose spoke about just now, but obviously the probation concerns are there, and I do recognize those. So I think at this time, I would just ask to set for an admit deny, and in the interim, Ms. Lopez and I can discuss possible resolutions.
Okay. The new case I thought was going to slow things down. I'm happy we don't have to deal with that anymore. Ms. Lopez, I can't remember when you were on this case, but I think I'll give you, some more time to try to figure out the next path. So either June 25th or July 13th.
June 25th, I will no longer be in your courtroom July 13th. So
Okay. What?
yeah, we're at that
2-year
time where
point
we're
again?
at that 2-year point again. I know.
Oh, boy.
But
Okay.
yes, I am available
Okay.
on that.
Okay.
If
I can set it pretty much whenever. So Ms. Rose, are you thinking you'll be here in person again? Do you think you want to appear
Yeah, I'll
virtually?
probably just stay up here until then. So
Okay.
yeah, it's summer. I can get outside and do other
Okay.
stuff. I mean, it's not, the dead of winter anymore. So
Okay. After that whole discussion about Frisco not being ideal, but that's 10 days. So hopefully that'll be a good decision. How do you get up here from Buena Vista? You take is there a bus?
I took the bus down to Leadville and then hiked the railroad tracks down to BV back in March, and my dad came and picked me up this time.
Okay.
So,
Okay. Okay. All right. How about Mr. Murray at 10, how about 10:15 on
10:15.
June 25th?
Mhm. That'll
Okay.
work. Yeah.
All right. Sorry, I don't mean to cut you off today.
you're fine. I get it.
Thank you for sharing your story again. And we got to just try to figure out a path forward. So we'll see you for admit deny on the 25th at 10:15.
Thank you, Your Honor.
Thank you. Take care.